He told me his train is delayed.
No worries, we know that goes.
I can guarantee you he was actually had lunch after 30 minutes. So.
Okay, would you mind? I'll be right out, literally right out.
Oh yeah, take your time.
Okay, thank you. Well, no, as soon as you guys are ready.
Yeah, Dimitri Karsten, nice to see you. Yeah. For a second, we can come back in. I guess we'll just agree and get going. If Charles is ready, how late he is, but.
Do you have any questions?
I think I'm pretty comfortable. I've seen a couple of these guys. Yeah, I talked to Mike over here. I feel like I have a sense of the work, yeah.
Okay.
All right.
Oh, look. Hello.
Yeah. So let me see if we can get Derek to just step that for a second. Just let him know you're here.
Think of the gas. Oh, heavens. I don't think I have it here.
Hey, how you doing?
Hey, Daryl Schaefer.
Guess I'll get started.
Oh, sure.
All right.
Where's the camera? Aren't they webcasting this? Is it that?
Yeah, it's good. I'm not sure.
Huh?
I think we are getting recorded on live.
They usually do that.
Welcome to the Supreme Court program at American University. I'm Dimitri Karsten. I'm a junior faculty at George Washington University Law School. Normally this is moderated by American University faculty. Mike Carroll could not be here because of travel delays, and I'm fortunate enough to be stepping in for him and to talk about with these panelists about this very interesting case. Western Geco, I think, is now the official pronunciation. Now the Chief Justice said it this way, although I've heard some different versions. Western Geco is one possibility. All of us, I think, were at the argument this morning, which I think will make it for an even more interesting discussion than it would have been otherwise. Just briefly, as is the custom here, all of the panelists besides me, the moderator, have filed amicus briefs in this case. So Derek Schaffer from Quinn Emanuel to my immediate left has filed a brief for Fairchild Semiconductor and several other companies, but I should mention that Power Integrations versus Fairchild Semiconductor is one of the sort of seminal cases in this line of extraterritorial damages, and obviously it's clear why one of his clients in this amicus has an interest in this case. Charles Dewan I've been friends with for a long time, and it's great to see him on the panel, is now working for Arch Street Institute. He filed a brief also on behalf of the respondent along with Electronic Frontier Foundation, and Irina Roisman is on the far end over there, and she has filed an amicus brief on behalf of the petitioner, on behalf of Western Geco for the New York Intellectual Property Law Association, and she is Ed Patterson, Tyler Belknap. So with that, I will just quickly set up the issue in this case, right? So what makes this case difficult, I think, is there's some disagreement even as to the question presented. So the official question presented in this case is whether the Court of Appeals erred in holding that lost profits arising from prohibited combinations occurring outside of the U.S. are categorically unavailable in cases where patent infringement is proven under 35 U.S.C. 271F, which is a special statute for infringement where there's not actually a domestic act of infringement. But the government, the Solicitor General, has broadened the question presented to include basically foreign damages stemming from any domestic conduct, which might include Section 271A, which is an issue in the Power Integrations versus Fairchild case. So that's one interesting aspect of the case, and one of the things I want to bring out today is how much does it matter that this is a 271F case officially. But I won't take too much time setting up the issue. Again, the basic facts here are you have a violation. There's not a dispute in this case that there's a 271F violation. Whatever the conduct as defined in that statute had occurred, there were prohibited combination being supplied from the U.S. with the intent that they be forming an infringing way outside of the U.S. And the question is, do the contracts that the plaintiff lost on the high seas involving this eventually made infringing combination, are they compensable as lost profits? So my first question to the panel is just sort of, and we can maybe start with Derek and just go down the line, is to evaluate how the argument went and what they're taking on what they've seen in an argument that was interesting or unexpected.
Sure. Well, I would commend the argument to anyone interested in this case. I think today's argument was about as scintillating as a Supreme Court argument gets, in every respect. I think it's an interesting, important case for the reasons that Dimitri said. You would expect that, Paul Clement, Ken and Shan McGam, the USSG's office would all do first-class jobs, but they really did. And I think the justices, not that they're out to score points with us, I think the justices did a great job of asking questions and pressing for answers that were important to their deliberations. So, in a lot of oral arguments, you have a sense that justices have kind of made up their minds about how they're voting, and they're really campaigning with one another, or some might say posturing, to show just how right they are and try to get some concessions that are going to help them write the opinion they have in mind. But I don't think that was happening today, at least in the main. I think that justices were really wrestling with the legal questions in the case. And so I think if you're interested in the case, I would really recommend, I don't know if the transcript captures all of it, certainly it's there in black and white, but there was real drama and I think really good advocacy and really good questioning. So I think it was a very illuminating argument in that sense. What does it illuminate for me? I think it's a close case. I think it's too close to call. I think, as some of us were discussing before we got started, I think there are some justices who seem that they've made up their mind, perhaps in favor of the petitioner. There was some of that coming through from Justice Kennedy, I thought, and Justice Sotomayor. I think that the other justices, I would have a very tough time forecasting their votes. And so I guess I'd leave it at that overview. I think that the issues that we're moving the needle today are the issues that come through in the briefs, and I think that we see as important issues in the case. Although, as Dimitri said, I want to be clear, in full disclosure, I have a rooting interest. It's on the side of respondent that is consistent with the positions and the interests of my clients. In the case that Dimitri was alluding to, we also represented Marvell against Carnegie Mellon University in one of the other important federal circuit cases that really stands by this presumption against extraterritorial application of the patent laws, particularly when it comes to damages.
Thanks. So just by way of introduction, I'm Charles Dolan, as Dimitri mentioned. I work at the RSV Institute. It's a nonpartisan, nonprofit think tank. Definitely agree with everything that Derek was just saying. This was an absolutely fascinating case. Really interesting arguments. First-class attorneys arguing. I think I wanted to touch on a couple of the themes that I've seen in looking at Supreme Court cases, particularly the patent cases that have been argued. I think there were a couple of them that really shone through in this argument. The first is the tendency of the Supreme Court to look for analogies or solid footing in other areas of law in order to understand some of these cases. Patent law is very complicated. I think the justices recognize that, which is why they come in without preformed opinions about what they want to do on the case. today's argument showed, a very, very strong interest in comparing patent law to tort law as a general matter. There was a lot of discussion of proximate cause, and Paul's graph came up. There was a lot of discussion of how patents fit into to that framework. There was also some discussion of whether or not patent law should be parallel to copyright law. That was another thread throughout this. So, I think there are a number of instances in which the justices were really looking to, what is another body of law that we can tether a decision to, so that we're not just kind of out on a limb making up something specific to patent law that doesn't have any basis somewhere else. The second was this real concern for overall policy questions. This was particularly prominent in Justice Breyer's questions regarding international comedy. This was partly something that we talked about in our brief, so I feel like I'm making a plug for it, but I think that overall a lot of the justices have been very concerned about what are the larger implications of this case, and what does it mean for industry overall, and particularly when it comes to extraterritoriality cases, what does it mean for international relations, and how are other countries going to respond to our decisions? So I think that was a second theme. The third one I think is somewhat specific to patent law, and it is this unusual aspect of the Supreme Court being really interested in extraterritoriality cases when it comes to patents. They decided the Deep South case and the Microsoft case. They seem to take on a lot of these questions on this very, very oddly narrow issue of extraterritoriality. And so the extent to which they saw that as sort of a special patent doctrine, I think it was kind of interesting to see to what extent they saw that as a special patent doctrine, as opposed to trying to tie this case to some of those other doctrines that I mentioned as my first point. So there was something of an interesting tension there that I think really added to the interesting dimensions of the arguments.
So I'm Irina, and I agree with Derek and Charles and Dimitri that the argument today was really, really engaged. The justices were very interested in the case and the particulars of the case, and then the consequences more broadly of the decision in this case. Going back, and one of the things that I was most struck with is that a predicate issue here is, as Demetrius said, what is the question before the court? And as I think Justice Kagan noted, the petitioner framed the issue in the context of 271F, which is what the case concerns. And the government and a number of the amici, including the NYPLA, broadened the issue out to basically cover all of the provisions under Section 271, because the same logic applies to all, and also because, as was pointed out, the decision in Western Geco very much relied on power integrations and a discussion of 271A. And what seemed striking to me, and I think quite important, is that even though there might be some disagreement between the justices on certain issues, they all seemed to agree that there was no reason to single 271F out, and it seems to me that whatever decision they reach, and I think they will reverse, that the decision will apply more broadly, and that damages, wherever they fall, will be recoverable if there's proximate causation.
So thanks, Sylvia. So I want to pick up on this point, and one thing on the point of causation. One thing I'm trying to understand what this case is about. Is it about factual causation, proximate causation, and what is the theory of how extraterritoriality fits into this presumption against extraterritoriality? And all of you have mentioned causation in some form in the brief. So, for example, Charles at one point talks about these two links, conduct in the U.S. and then foreign conduct being kind of too remote from the damages. I think you, Derek, in your brief talk about power integrations, and so this idea of foreign acts as being intervening causation, which is the sort of the language power integrations used. Irina, you talk about more about the principle of adequate compensation, which is which is factual causation. Really, it's a focus on factual causation. But I think it's mostly conceded in this case that there is some kind of a factual connection between the infringing acts in the U.S. and these lost sales. So maybe to focus the discussion, what is the role of proximate causation? How would you say extraterritoriality affects the proximate causation inquiry, if at all?
Sure.
Start with you, Derek.
Maybe I'll start with that in the abstract. I agree with Ken and Shanmugam's answer today for ION, which was basically, to some extent, it's a question of, just as you said, Dimitri, the causal chain. And the real question is there some intervening foreign conduct that cuts off the foreign chain? And some justices, understandably, are drawn to the notion, well, can't we just handle that under longstanding, non-controversial concepts of proximate causation? But I think everybody has to recognize in this case, ultimately, that there really isn't a proximate causation issue. ION was candid about that today. 271F itself requires, in order for there to be liability, that the infringer have specifically shipped the component with the intention that it would ultimately be assembled into the infringing product. So that is a component of liability in 271F that really ensure, and then the Federal Circuit, for purposes of proximate causation, has asked that question in terms of, really, is it reasonably foreseeable that particular damages are going to follow, and if so, there's liability for those. So unless the Supreme Court would go even further and basically change the law of proximate causation in the patent context, I don't think that proximate causation can do the lifting here to cut off the causal chain and to disallow the extraterritorial application and the calculation of damages based on foreign conduct. By the way, just to emphasize, in this case, I do think it's relatively clear that the award on the facts does rely upon intervening foreign conduct. Why is that? It's a somewhat novel and I'd say at least uncommon chain of damages, the way that Western Geco has calculated its damages, because they don't license their patents. They don't sell the patent to anyone else. They use it when they themselves provide the contracting services in question. They use their patented technology to do deep sea surveys, and they're the only ones who have it. They're the only ones who do it. So the way that they calculated their damages is pointing to contracts abroad that, I think for the record indicates, these contracts were entered into abroad, they were conducted abroad by foreign entities and foreign vessels. And so it's the loss of those foreign contracts, essentially, that resulted in the award of lost profit damages that's at issue. So under proximate causation, I think one would say, consistent with Federal Circuit law, there isn't really a question as to proximate causation. And the way that I think about the presumption against extraterritorial application in this case is to say it's basically proximate cause limitations on steroids. It's really what the Federal Circuit said in Power Integrations, if you are relying upon a chain of events that extends abroad, the intervening actions by foreign entities operating abroad cuts off the causal chain. And that makes this a legal determination that judges can make, not just leaving it to juries. I think it's a relatively bright line rule. It provides some predictability and some stability to how patent cases get litigated and get adjudicated. And I think you need that in order to really vindicate the principles that drive generally the presumption against extraterritoriality, especially in patent cases where the Supreme Court has indicated those concerns are at their zenith. So, and there is a question, as I understand it, of but-for causation in this case that ION would be saying needs to be decided on a remand. They really didn't get into that issue, those questions today. I don't think that's part of the question that's up before the Supreme Court, but that's what they're bracketing as requiring potentially a further decision by the Federal Circuit on remand. Proximate causation, traditionally, I don't think that there is a proximate causation question. I do think there's a very good question, as I've indicated, about whether the presumption against extraterritorial application of the patent statute basically stands in the way of this award.
So, in thinking about the way that the court treated proximate cause in this case, it's interesting because there's a sense in which they could have decided the case without talking about proximate cause at all, right? I mean, this is an extraterritoriality case. Other extraterritoriality cases are based basically on the notion that a patent is a sovereign grant of power, and, that's why the power ends at the borders. tort concepts don't necessarily have to come into that analysis, and so far they haven't. So it was interesting, why does it show up? It shows up, I think, in two contexts, at least as far as the parties' argument. The first was in a way of alleviating concerns. I think a number of the justices were fairly concerned about the idea that if you stop compensation for injuries once the actions start happening overseas, then are you not sufficiently compensating patent owner? Or sorry, the other way around. If you start allowing damages overseas, are you allowing for so many damages that there will be international comedy questions and potential problems of double recovery? All sorts of horrible things. Proximate cause came up a number of times, saying, no, don't worry, we have a doctrine that will take care of that. That'll prevent the damages from going too far. So that came up a number of times, and the other way was just as a manner of interpreting the law, more or less by saying that Section 284, the provision that provides for the damages that are given to a patent owner, that incorporates concepts of tort law such as proximate cause and such, and as a result, that was simply a legal doctrine that attached to the statutory interpretation. This is why I found it fairly interesting that ultimately the argument didn't really go into the words of the statute all that much. There are a lot of very interesting statutory text arguments that could have been made, and I think there were a couple points where Justice Alito started trying to go down that path of looking at the particular words of Section 271F and seeing, do those provide, particular textual basis for this. But because of the fact that the arguments focus so much on just applying tort doctrines to Section 284, I think that discussion was, in my opinion, somewhat unfortunately, kind of lost, which is unusual because generally when the court has decided these sorts of things, it has been on very, very technical statutory grounds, particularly also given that the case argued immediately before this one was entirely about statutory construction, about, interpreting particular words in the IRS code. So I found it fairly interesting that the argument didn't really go there.
So I guess I would say that I don't think the presumption of extraterritoriality applies to the proximate cause analysis or has work to do there. I really do think it's and we discussed it at length in our brief, sort of the history of the presumption and how it's used. And it is really a canon of construction. And I think once you have domestic liability, as you did here, the presumption's basically inapplicable. And Justice Kagan asked this question, I think, of the government. Basically, and Justice Alito raised it in a different way, but raised the question of, with the presumption, do you have to apply it to Section 284 at all? And if you do, is the result any different? And the government said, the result's not going to be any different in either situation. And I think. The petitioner also explained that, it makes much more sense that once there's a finding of liability, that you're not applying the presumption and sorting out how it works with respect to a damages provision. But in either case, it basically works out. So I don't think it plays a role. And the other thing on this that I found interesting, which is the respondent said was asked a number of times, well, should patent owners be fully compensated? Aren't they going to be undercompensated in these kinds of situations? Are you asking for them to be undercompensated? Justice Kennedy was the one that was doing that pushing. And I believe he said at one point that, well, if you have a situation where you have a product that's manufactured in the U.S. and infringes a patent, and then it's sold ex-U.S., you can recover for that, he said. And they think the moment you say that, you basically gave it all up, because then the only thing that it comes down to, and the only role that foreign conduct and foreign relationships have is in analyzing, whether you in fact get, in analyzing the facts, and in doing the specific factual analysis for a particular case. But as soon as you say, and I believe correctly, that you infringe, though it's currently inconsistent with power integrations, but if you manufacture in the United States and you infringe and you sell abroad and the patent owner can recover for that, there's no legitimate distinction in any other circumstance. So I actually think the respondent, quote unquote, gave it all up.
So that's interesting. I want to pick up further in this discussion between the respondent and Justice Alito, which a couple of you brought up, and maybe the statutory issues. I mean, they were referenced, but maybe we can sort of say what might have been and have this discussion here, and it could be sort of try to be a justice for a moment and ask you a couple of questions that I wish had been asked. So, right, so the discussion with Justice Alito does point to the statute, and maybe, right, analytically it's important whether the presumption against extraterritoriality doesn't apply at all to damages, or it does apply but has been overcome in this case, or does apply has not been overcome in this case. And I think what this exchange was pointing to, and the statute, does reference foreign events, right? It talks about combination of components outside the U.S. I think Justice Alito was implying, I'm not sure if it was implying that the presumption was overcome with that language or not, but to me, it was interesting. And so, assuming it hasn't been, and that's the respondent's argument, how would Congress have to redraft Section 284? So, say Deep South comes down, they pass to 71F. What more would Congress need to say to overcome this presumption, assuming it does apply, given the language to 71F? And kind of my second part of the question, under respondent's theory, and I think, Derek, you were pointing at that a little bit with the citrus of contracts, this idea, under what circumstances would lost profits be recoverable at all? Would there need to be a contract in the U.S., even though the infringing activity still takes place abroad? Or are they just not recoverable under current version of 71F unless 284 is amended? So, long-winded question, but my basic point is, what would you need if you're doing belt and suspenders as Congress and you want these damages to be recoverable, and can they ever be recovered now, assuming respondent's theory is correct? So you guys can go in any order. I'm just, this is what I'm curious about, and this is me being the justice here.
Well, I mean, it would be pretty easy for them to write it extraterritorially, right? They could simply say, you shall be able to recover for, patent infringement wherever it occurs. Like, just take out the words in the United States in Section 271A, and you have an extraterritorial.
And it's not enough to say induce a combination outside the U.S. in the remedial, in the liability provision, right?
Or a damages provision could simply say, to the same extent contemplated by the liability provision, and kind of incorporate by reference that way, which I think would show that Congress had thought about it. But while we're talking about the exchange with Justice Alito, I just want to spotlight one aspect of it, which I thought was really fascinating. Justice Alito authored RJR Nabisco for the court, which is a very important case in terms of this case and this argument, and the respondent was leaning extensively on that. The petitioner did less work with it. But, there's a lot going on in the RJR Nabisco case, which is really about a private right of action under RICO and the extent to which violations of RICO abroad, predicate acts abroad, can justify recovery by foreign plaintiffs that are suing under U.S. law for a lot of the conduct and a conspiracy that happened abroad, at least in large part. And the court was very strict about enforcing the presumption against extraterritorial application, which was not an easy thing for the court to do in RJR Nabisco, not an easy thing necessarily for Justice Alito to write. The reason why is the court acknowledged that RICO quite explicitly has as its predicate acts certain acts that really would naturally occur abroad or could only occur abroad. And so there's no question, according to the court, that yes, that those substantive provisions of the RICO do overcome the presumption against extraterritoriality. But then the court asked separately, now let's look at the portion of RICO that authorizes a private right of action and see if that was meant to apply extraterritorially so that the private right of action is coextensive with the international substantive reach of RICO. The court said no. When we get to the private right of action, there isn't separate language from Congress that indicates it meant the private right of action to extend extraterritorially. So these foreign plaintiffs, these private plaintiffs, are out of luck. And in the course of reaching that holding, the court made clear quite explicitly that this analysis, this incorporation of the presumption against extraterritoriality, that applies to substantive provisions, it applies to jurisdictional provisions, and it applies to remedial provisions. Each of those needs to be separately scrutinized against the presumption against extraterritoriality. So then you have the respondent today saying to Justice Alito, well, as you wrote, Your Honor, in RJR versus Nabisco, and some of us are waiting to see how Justice Alito will handle that, and he said, well, RJR Nabisco is different for reasons that I won't get into right now. And some of us are scratching our heads and wondering what those reasons are. And then as the colloquy continued, I think Ken and Shanmugam did a pretty good job of explaining why actually the RJR Nabisco decision is quite analogous and helpful for respondents' purposes. Justice Alito resorted to saying, well, let's just put RJR Nabisco to the side. You tell me why this makes sense. So I think it's, I do think that this is not, as Charles points out, there's something different about how the court has analyzed extraterritoriality in patent cases. I think that makes some amount of sense. But also, it's not the first time that the court has written about the presumption against extraterritoriality. It has recent jurisprudence on this. And I do think that's one of the things that does suggest that, even if it may be tough for Congress to write separate remedial provisions that reach extraterritorially, you want to make that a substantial hurdle. You want to make sure that Congress has thought about it. And so, you would expect Congress to do that in this context no less than the RICO context.
Any more thoughts?
Yeah, I think the one thing that I'd add to that is that when it comes to patents being treated sort of specially when it comes to extraterritoriality, this case kind of exemplified this tension. On the one hand, that normally under tort law, you are responsible for the consequences of your actions that are approximately and factually caused. On the other hand, it is generally pretty well understood that when you're outside the United States, you can infringe United States patents, and you are not responsible under the United States law for having done so. So how do you resolve a situation where somebody is infringing a patent outside the United States that is caused by something that was happening inside the United States? And this is where I think some of the comedy concerns that were discussed during the case play into that sort of tension. This question of what would happen if some nation outside the United States that had different patent laws suddenly started telling U.S. companies that they were infringing in the United States some foreign patents, right? I think that's why those sorts of questions came up, because you have that sort of tension in number one saying that tort law ought to apply like tort law applies, but on the other hand saying that generally the rule is if you act outside the United States, you can't infringe U.S. patents. So I think that that came up a couple times.
Just to add to that a little bit, I mean, there is something about patent law. We get this extraordinary thing, a monopoly, as to certain inventions and within certain bounds, and part of those bounds are they're territorial. The U.S. has its say about U.S. patents and how they're enforced on U.S. soil, but other countries necessarily have their role to play about their patents and what are the limitations on the patents, what are the limitations on any recovery. And there is this problem, this concern that if U.S. patent damages really do sweep around the world, then a company that's in the position of Western Geco, once it can say that a U.S. patent was infringed and it can get to the same calculations for the same foreign damages based upon the same foreign contracts, well, haven't you really ousted other countries from having their fair say about the limitations on their patents and their patent damages and their patent actions? There really isn't, I think, a satisfying answer on that. Maybe Irina has it. For the petitioners, there is a certain natural effect that has of removing incentives for companies like Western Geco to be getting certain patents on specified terms abroad and enforcing those patents abroad per those specified terms and whatever limitations they may face in foreign courts.
Yeah, I don't see that as a problem. So let's say there's a French patent or an Italian patent or whatever it is, and if EN did something to infringe those patents there, it could have an issue there. But they infringe a U.S. patent, and this is about compensating them for that infringement. And Section 284 provides for full compensation, for complete compensation for the injury. And so it seems to me that to allow less than that, and that's again what Kennedy was pushing, basically to allow less than that, and to really stop it at the border in terms of recovery, even if your injury goes beyond the border. And I think injuries will increasingly go beyond the border just because of what the world is like. And so, to stop it, you undercompensate, and you hurt patent owners, innovators, and you hurt innovation. And so there is, and that's largely why the NYPLA put in its brief, because this is being able to compensate for the injury is part of, one of the keys to fostering innovation, right? Because if you're not compensated, why are you going to bother? And to get patents, to disclose your inventions. And so from that perspective, stopping at the border doesn't make sense. I can see that if you are, I think cases like where you manufacture in the U.S. and then just sell it abroad should be really easy in terms of proximate causation, and hopefully, and potentially in terms of demonstrating lost profits. But as you get into all of these foreign situations, you could have a very complicated set of facts, and you may, not be able to prove damages quite easily. And so I think those are the right ways to address those issues, not the presumption. I also think that the presumption of extraterritoriality does not have, it has a very long-standing role in U.S. jurisprudence. It has been a canon of construction for more than 100 years. I don't think it has a special role in patent cases. And, the last time that the presumption of extraterritoriality was played up a lot was in the Lifetech versus Promega case. And again, it was, in all the briefs, tons of discussion, and it was nowhere in the Supreme Court's opinion. And I think similarly, it does, it doesn't belong here, because there's domestic liability. There's a statute that allows you to be compensated for that domestic infringement, and that should really be the end of it. And then you have to prove your damages.
So I'm glad we're having this discussion, because to me, again, one of the most fascinating questions is this idea: are lost profits never, these kinds of extraterritorial lost profits never available? Are they sometimes available depending on some case-specific comedy concerns, or perhaps, as the respondent was trying to suggest, maybe if the situs of the contract was closer to the U.S. somehow maybe compensable, or are they always compensable as kind of a general principle of compensating for the infringement? And I'm not sure where the court's going to draw that line. I mean, clearly, in this case, in this particular case, is maybe not a grave one for respondent, because there's not another jurisdiction that is asserting its right, in the patent of high seas. But if the case is written general enough, of course, that'd be a problem, or maybe it can be cited in these case-specific facts. But given our earlier discussion, what I was surprised by, and maybe this is just Paul Clement saying that, but Paul Clement says, my friend on the other side conceded that an injunctive remedy is available. I actually haven't checked if there's such a concession in any briefs, but that didn't seem to be challenged, right? And it says if you've got the injunctive remedy, it would happen at all. I would think you wouldn't concede it and say, well, irreparable harm doesn't count or something if it's so broad, or you can make some kind of an eBay argument.
Well, so that's the point, right? That it's available, but there are other considerations that go into it that they didn't really talk about. Like, that would be my answer.
So I think that, in fairness to the respondent, I think they gave the answer they had to give. I think it's correct. Let me see if I can try to explain my advocacy of it. I think it is true that one has to accept, I think, given 271F, that there is liability for having supplied a component with the intention that it's going to be combined into an infringing product abroad. I think also an injunctive remedy does attach to that. I don't know, and keep in mind what the limitation would be on the injunction. I think all of us will agree to this. The injunction would not be an injunction against anything around the world that would constitute infringement under U.S. patent law. The infringement would be circumscribed by U.S. territorial boundaries and the terms of 271F. So what the injunction would say is, thou shalt not supply from the United States this offending component with the intent that it's going to be combined into an infringing product abroad. That's the injunction. And it has limited scope and limited practical effects. And one thing that ION, in the face of that injunction, or any particular would-be patent infringer can do, any defendant, is, okay, we're going to relocate our operation abroad prospectively outside the reach of U.S. patent laws, or we're now going to supply this component in a way that makes absolutely clear to everyone it can never be used in combination in a way that infringes. But basically that defendant would be on notice of what is the offending conduct within U.S. borders. The U.S. court would be regulating that conduct within U.S. borders, and there wouldn't be any ripple effects abroad that would matter to the U.S. court or the U.S. legal analysis. And I do think that that's the right analysis consistent with the presumption against extraterritoriality. I also think that that should provide some satisfaction and some comfort to those who say, what an absurd result. Congress said in 271F, you're going to be liable for this, and that's going to matter to substantive patent law, yet you have no ability to recover lost profits when the source of those lost profits is contracts abroad. So I do think that that to me is a satisfying and correct answer. I agree, though, it would have been interesting to hear about that more at the argument. It really did not get covered much at all.
Any more thoughts, Rena? No, I just thought the injunction part of it was interesting, right? Because, right, the prohibited conduct here, to the extent that infringing acts abroad are implicated, is the infringer, the putative infringer, right, just can't get the supply from this particular supplier who supplied these components with intent and so on and so forth. I mean, they can do it themselves or get it from France, you know. And that actually, so the statute, and your brief, Derek, has helped me understand this. And the reason why I have my computer in front of me is like certain things just click. I mean, on this certain, and that's why we do my notes. In a certain way, right, F1 and 2 pattern B and C, right, as sort of indirect liability provisions, but they really aren't, right? They create, the combination doesn't actually have to be made. It's the intent and the supply that they act. So I actually was just thinking this all the way through. And suppose, right, a contract is entered into, and then the end user's business interests change, and they never actually make the infringing combination. So there's no suit possible for direct infringement in another jurisdiction. So we have an odd situation where the infringing acts, directly infringing acts, aren't actually performed. There's no comedy problem because nobody can sue them, and there's no possibility of double recovery, right? Because they actually didn't perform these acts. So I don't know how this plays out, but to me, that's a fascinating feature of the statute, which makes it kind of the opposite of Akamai, right? At one point, respondent mentioned, well, they're trying to hold us secondarily liable, but this is really a form of direct liability that looks like secondary liability. So your thoughts on this?
I totally agree with that observation, but I would say, because earlier there was characterization of 271F as a provision that does look extraterritorially or, you know, takes into account foreign conduct. I think in just the sense you articulated, Dimitri, it really doesn't, right? It looks only within the four corners of the United States, to the point that, as you say, it is really irrelevant, strictly speaking, to the 271F liability question, whether anything happens abroad once the product is exported. If it's never combined, but you had the intent for it to be combined, you're still liable. If the foreign counterparty goes out of business or is enjoined by a foreign court because what it would be doing there would constitute foreign patent infringement, you in the United States have still violated 271F, and you can be held to account for that, even though there wasn't this intervening foreign action that would have triggered the damages, the sort of damages calculation that's being argued about in this particular case.
So the thing I wanted to bring up was there's a really interesting line of questioning from Justice Sotomayor about, you know, you can always recover reasonable royalties, based on this sort of case, but she was complaining that, you know, why should we have to award hypothetical damages when we know what the real damages are. And this is interesting because, a lot of patent cases deal with hypothetical damages. Most cases are reasonable royalties, and we're fairly used to that. But I think that outside the patent context, it does seem really weird to say we're going to talk about hypothetical negotiations when there was an actual damage, when actual damage happened. In terms of what you were just talking about, with regard to I just lost my train of thought. But yeah, I think that there was I think that sort of question of you can still get compensated, but this compensation looks very odd to a non-patent person struck me as something of a difference between the sort of patent law that we usually work with and the more general law concepts that my guess is the Supreme Court tends to be more familiar with.
Yeah, I mean, my reaction, Dimitri, to the hypo that you posed is it's hard to see damages of any kind in that situation, right? Because the combo isn't made. So if the combo isn't made, that's okay, and so that's just gonna cut it off. And then I thought I did think that the reasonable royalty discussion was interesting, and I think Clement started with that sometime early in the argument, pointing out that there's this critical admission somewhere in respondent's brief on that issue, and I have to say that I agree. Well, I agree. I think the respondent has made a variety of critical admissions. One of the critical admissions is that admitted today that basically you can recover for sales that are consummated abroad. So in a variety of contexts, then it doesn't matter where the damages actually fall. So that was a critical admission. And then the other critical admission is that reasonable royalties are available. And if reasonable royalties are available, reasonable royalties, as Clement expressed, are the floor, they're the bottom. And this is lost profits are another form of damages, and there is no reasoned basis, I think, for the distinction, and that was for any distinction between the two, and I think that was Clement's point, and it seemed to me a good one.
Just two observations, if I could. One is, I think the interesting thing about your hypothetical nature, one of the interesting things about it is, I actually think reasonable royalties would be the correct answer to the damages question there, and I think we should all be comfortable with that. In your hypothetical, right, it was shipped outside of the United States in a way that violates 271F. It happened, to everyone's surprise, that it wasn't ultimately combined into the product, but the way, and Charles is right, this is very much a creature of patent law, but the way that you calculate a reasonable royalty is according to these Georgia-Pacific factors, come from a district court case and been with us and blessed for a long time, and it's very much fact-sensitive, and you can do all sorts of things with it. But essentially, what the hypothetical negotiation is trying to do is saying, well, we have an infringer, we have the patent holder, let's assume that they were at the bargaining table and somehow negotiating their way to a license. What would the terms of the license have been? And I think the hypothetical negotiation for Dimitri's hypothetical is one where you have someone who'd be violating 271F, they need a license to the patent so that they can take this component and they can export it abroad in a way that will be used in combination to infringe, and what would they be willing to pay for that? And you come up with a reasonable royalty, and that's what they're going to owe for their violation of 271F. And that, to me, is a satisfactory answer in that case. I think it could be a satisfactory answer in this case as well. And as to the point that I do think things start to break down for the respondent here to some extent when you say, well, now let's assume let's undertake the inquiry into the hypothetical negotiation. Does the hypothetical negotiation take account of the way that this component is going to be sold into a foreign market where it's going to be used as part of these foreign survey missions, and there's value in that? So is that something that you can take cognizance of when you talk about the hypothetical negotiation? And I think the answer to this, which I'll admit is not perfectly satisfying, but I think it's the best available answer in the case, is, well, you can assume, for purposes of the hypothetical negotiation, there'll be some foreign use that's part of the value, but what you're saying is, what is the value of exporting this one component? What is that worth in the United States at the time that it's being exported? And you can look at that through the prism of U.S. law and U.S. operations and say there's a certain value that U.S. violator is realizing. That's part of the hypothetical negotiation, but that does seem fundamentally different from saying, now let's just look at what happened overseas, let's look at all the foreign contracts, and based upon that alone, calculate what is the total lost profits award. The latter exercise, I think, is more offensive to the presumption against extraterritoriality, and that's really what respondent stakes their case on.
That was where my train of thought got lost. So, thank you for answering what I could not think of. Yeah, I think there were a number of instances during the argument where the court almost indicated that they thought that a reasonable royalty just wasn't enough, right? I think this went to Kennedy's question of why aren't you offering? Are you saying that they don't get full compensation? This goes to Justice Sotomayor's question about why are we only awarding hypothetical compensation based on reasonable royalty rather than full compensation for actual lost profits. In a sense, if the problem is that a reasonable royalty is insufficient compensation, you've got a problem for patent law across the board, right? That's not an extraterritoriality problem. So I think that was interesting, but it again points to the fact that the Supreme Court is looking to answer this on non-patent law bases. That traditionally, you don't look for the sort of hypothetical negotiation. You look for how was somebody harmed, and I think that there is really the sense that should be the real metric of damages. Whereas, I think that folks like me who have been spending all of their time in patent land are just very used to the concept of royalties being the right measure.
Of course, this is a recurring theme and not a good one for respondent. The Supreme Court grants review in cases coming up from the Federal Circuit, looks at some arcana of patent law and says, where's that coming from? That's not how we think about X, Y, or Z when it comes to other cases that are on our docket. And the trend has been really for them to push back on the Federal Circuit's treatment of patent law as its own specialized field. So that general trend doesn't bode well for the respondent in this case. But I do think that the court is really wrestling with the problems of extraterritoriality that do seem to more likely arise or more specially arise in the patent context. That was, I think, evident in the argument too.
So these comments are useful, and to me, Justice Kennedy's reaction, eBay was concerned about non-practicing entities, right? Kamal, I think it was Justice Scalia's opinion, but and finally we have an entity who is practicing and very much practicing. You don't want to give them full compensation, so I think that some of that maybe was coming through policy-wise, but of course there are countervailing policy concerns too, and whether reasonable royalties are really reserved for these just troll. I mean, the Supreme Court used the word troll, so I think I may use it here, right? But this idea that these are these are just for those people, when eBay doesn't apply, when lost profits, real remedies don't apply. But the question is maybe reasonable royalty is a real remedy. Who knows, right? But you've humored my hypotheticals long enough. Perhaps it's now time for the audience to put in. I have about 10 minutes late, and I do want to leave some time for questions. Please, sir.
Thanks, Dimitri. Jordan Engelhardt, work with Irina on the MI IPLA brief. I just wanted to pick up on something, Derek, that you mentioned and see kind of where it leads. The idea of intervening acts or in foreign countries in this context, and wonder what the consequences of that would be in practice. So, from my perspective, and I'd like to hear how you would come out differently. To me, this would have a consequence of favoring certain economic activity over other economic activity. And since we're at an argument today where the other case related to taxes, I sort of draw an analogy in my mind to tax policy, where ideally tax policy should be neutral to the type of economic activity and shouldn't encourage certain economic activity for tax reasons. And so, if you have a sale of a product and it's a very simple set of facts, one would say, okay, there is no intervening act, so foreign damages are collectible. But if you have a more complex factual situation where the value of your invention comes from how it's used, like like in this case, where it's a machine used to perform a service, all of a sudden those types of inventions would be valued less as a matter of patent policy, and that seems to be a bad thing. That it would create economic consequences that sort of discount the value of certain types of inventions?
So I guess it would depend on specifics. I recognize. I mean, it's not like this is self-defining and self-executing. I think that whichever way this case comes out, the court's going to have more work to do as it kind of refines the principles in the application. But as to the value proposition, I do think that patent law should look at the value proposition. I do think that's the reasonable royalty analysis. And my submission is that you really should be looking at that within the lens of what is the U.S. infringement or the U.S. infringing activity. What is the activity in the United States that gives rise to liability? And Jordan, that looks at everything. One of the questions that gets asked in connection with Georgia Pacific is, how much would it cost for me to relocate my operations so that whatever I'm doing that's at issue in the case isn't going to run afoul of U.S. patent laws at all? And if it costs $10 million for me to relocate, then it's not going to be a sensible result for me to be rung up for, $10 billion because someone goes through a causal chain of the way that a U.S. active infringement has then had ripple effects in terms of what other actors have been doing around the world. And that's, I think, part of the concern that's animating this case. And, as to the question of how complicated the intervening acts gets, I don't mean for that to be complicated. I don't think ION means for that to be complicated. I think Ken and Shanmugam's answer to the question of why could there be a recovery for a sale, if the hypothetical is ION is selling the product, it's deriving the profits. As I understand Cannon's answer to that, it's because that is U.S. activity. There's nothing happening abroad. And when he's talking about the contracting, he's saying there'd be an analysis of, are these foreign contracts or U.S. contracts? But essentially, if the contracting activity is in the United States and the monies are flowing into the United States, that is a case where the U.S. violator of 271F is basically, providing the basis for the damages calculation in the United States, and the presumption against extraterritoriality isn't offended. Now, I think that there can be cases that are more in between, and you could have arguments about, is this a foreign contract or is it a U.S. contract? But that would be what determines whether it is a permissible damages recovery or it is not. And if you don't go through that exercise, I really do think you're rendering irrelevant the foreign patents and foreign patent enforcement, because if you can recover every penny of your damages around the world through the U.S. action, what incentive would you ever have to be obtaining the foreign patent and enforcing the foreign patent?
Any more questions out here? Yeah, I've actually thought about this too, right? I think one idea is people don't generally like to sue end users, right? And this, this concept of these indirect liability like statutes are there, in part maybe to make it easier to reach conduct that can be reachable in different ways. But obviously there are limits to that, right? If you can have double recovery and so on. But no, I think that's one of the interesting points that comes out of the case.
And I would just say that I think it's less difficult, arguably, for Western Geco to be enforcing its patents against the end users, because, of course, as everyone emphasizes, Western Geco's business model is to be practicing its patents. It's not licensing them. So it is competing against the end users for these contracts for surveys. And to me, there's nothing that bothers me about saying to Western Geco at the end of this case, if you think that foreign vessels, under the flags that they're flying, are practicing your patents, take it up with those foreign vessels courts and state your patent claim and obtain your recovery that way.
Please, the floor is still open for about 3 minutes, and the panelists, I'm sure, are eager to answer your questions if you have them. I'll leave some time. Any more thoughts? Well, I guess if not, we'll close. But thank you for the panel for making my job very easy, and I think we're all glad we braved the rain this morning to attend the argument and then made our way down here. Thanks so much for coming again. Thanks to American University Law School for hosting this event. This is great. Thank you, Rudy.
Pleasure.
I guess there is a reception. I'm not sure if it's right outside or downstairs. Again, I'm not local, but some of you who are here may guide. Is the reception local, or is it up here, or is it downstairs?
I think it's outside.
It's just outside. Okay. Oh, awesome. Easy enough. Back.